Glad to have everyone here this morning. If you didn't get it when you came in, there is a handout with the slides I'm going to be talking about at each corner back there, so maybe someone can bring you one if you raise your hand, or you can step back and get one. We'll get them to you. On each corner there by the doors on a chair, okay? As I said, it's a very important, I was telling somebody, very important handout. There will be a quiz afterwards, and and Ben will be grading it. So anyway, good to work with Ben. He's, like he said, he's been doing this, 3 years now, you said?
I think so, yeah.
And so he and I work closely together on a lot of this. The introduction for me could just pretty much say manure lawyer, right? And proud of it. All right. Anyway, enough about me and Ben. We can get to it. Ben gave me a little bit of a hard time that this isn't quite as thick as it has been in past years. I don't know if that means I'm just getting tired of talking about stuff or if it's better. I did get asked, well, any major issues? And I'd like to say nothing major like some years we've had. We will... first of all, let's give you the overview, the contents, and I do catch, I shouldn't use the word crap, how about guff from people sometimes about, you have a table of contents to your PowerPoint slides, but I like to give you something that I know you'll go home and read it all, but like to at least give you more of a reference than just some bullet points, but we'll see. You let me know. That's what those forms are for. Today, I think what we'll talk about, Ben, and you and I talked about some of this. Iowa DNR is front and center. We'll talk about some of the new rules that went into effect in June. And then what I call DNR rule effective dates and enforcement. I mentioned to somebody, and you don't need to leave or flip forward if you don't want to, but sometimes my slides get a little hard to read, and if you go to slide 15, you're going to say, McAfee, how in the heck am I supposed to read that? All right, well, what I want to do is show that to you on the screen as an example of something I want your input on. I've worked with some of you consultants on one of the issues we have out there is these rules over the years have changed, right? Some areas, and when certain people go out there in an enforcement capacity, DNR, they often look at what is the rule today, and they look at that site and they say, well, you don't have this, you haven't done this. Well, hold on a second. When I built this thing, that wasn't the requirement. So, and we've worked through those issues many times, and some DNR people are right on top of it, some are not. What I'd like to do is develop more materials that you can use as consultants and producers that you can look at a little easier than trying to decipher one of my darn slides or something. And of course, we have the Environmental Handbook on the Iowa Pork Producers Association website that goes into more detail. And what I'm looking at that slide 15 is doing more of something like that that gives you what I think is a tool, and I keep talking about it, so when we get there, I'll go into a little more detail, but helps you look at, data construction, this requirement, here's what I needed to do then versus what is the rule now. So I'd like your input on that as we get there. Composting, we're going to talk about that. I haven't talked about it for a few years, but I'm getting questions. I'm not going to say more. We're going to talk about that this morning. And then DNR rule enforcement, we'll talk about those things when we get there. Federal EPA air emissions issues. I've been doing this stuff for 30 years, and I swear some of this started right after I started some 30 years ago doing the It just keeps simmering in the background and doesn't seem to go away. We'll talk about that for a little bit. Ag nuisance. Again, I keep saying what we're going to talk about. How about putting in the category ag nuisance, ag fraud, and trespass laws? I, as a lawyer, do I ever get to talk about the good things that happen out there? No. You always want to hear the bad things from me. What's going on? Where am I going to get sued, or what do I have to do? How about we talk about some good things? Ag nuisance, I don't know of a single case on file in the state of Iowa right now against a livestock operation for nuisance, okay? Not too many years I get up to sit up here and say that. 2, ag fraud, ag trespass laws. I refuse to use that term. Many of you know there's a term that the media uses for ag, and it's spelled G-A-G. I don't use that term. I don't like it. Anyway, that has pretty much been settled by the 8th Circuit just a little over a year ago, and since then it has been affirmed by the district court. We're in good shape there. And then California Prop 12 and Massachusetts Question 3. Okay, so much for the good news. All right, anyway, we'll talk a little bit about that and where we stand. Okay, Ben.
Yeah, so if you could just start off, and if you guys, first of all, if you guys have questions, just feel free to raise your hand, and we'll make sure to come around with the mic. So this is very, we want to keep it informal. So if you have questions as we go along, feel free to raise your hand, and we can do our best to answer those. So I guess first up here, looking at these Chapter 65 DNR rules, Eldon, if you could kind of just go through kind of what, how this kind of process started, and then where we are today here.
All right, I'm having my progressive lenses are not focusing real well down here, so if you see me tilt my head. Anyway, I'll say it again. If any of you who may have just come in, if you don't have a handout, they're on the chairs at each door. Please go grab one. That's what we're following here today. The rules that went into effect June 19th, 2024, primarily it was restructuring and technical, changed where things were. And for people who have been doing this a while, the worst thing they can do to me is change the rule number and move it somewhere else. And I think, okay, I kind of liked where it was before because I could find it, but they do have a table on the DNR website of a cross-reference table showing the old rule number and where you can find it under the new rules. Maybe not important to a lot of people, but it's there. Other non-substantive changes include adding a general division, which applies to all. That used to be, we had confinements in one division, open feedlots in another. They've changed that. One of the things that you consultants use a lot, and others too, the appendices, they're no longer in the rule. They're on the website, but they're not actually in the rule. They're referenced. We won't get into why. How's that? Okay. How about some substantive changes? I'm on slide 4, and this is kind of non-substantive. The first one, those of you who have been around a while, like me, remember back in 2006, Iowa adopted a director discretion rule that gave the DNR director discretion to pretty much step in and say, hey, you've done everything you need to do, but you know, I think this is going to have a negative effect on the environment. And I'm paraphrasing. That rule, when adopted, extremely controversial, and in fact, the Attorney General, as I think I say here, it was never used because the Attorney General gave the advice that it had exceeded the DNR's statutory authority due to an objection by the Rules Review Committee. Never used. It's taken out of the rule, okay? Substantive in one aspect, non-substantive because it was never used. Again, a very controversial issue in 2006. Floodplain regulation. Now we use a DNR siting atlas, The map is the rule if you're applying for a permit and need to look at the floodplain regulation. All right. How about something that has been controversial but is still didn't really change, and that is karst. And many of you know karst is a geographic, if that's right, geological formation in northeast Iowa where the bedrock is porous and is more susceptible to groundwater movement, concern about groundwater contamination, etc. Those karst areas obviously have been there for millions of years, but we've always had rules that treat karst areas differently as to what you can build and how you can build it. The proposed rule changed those karst regulations significantly and made them stronger. In the end, the EPC and DNR adopted a rule, no changes. It's like it has been before, except for if you have to do the soil exploration, it now gives you a certain number of feet, and you have to go soil corings down to 7 feet below the bottom of the proposed structure. As I noted in that last bullet point, previous DNR drafts included reduced separation distances for livestock. We'll talk about this a little more in a few minutes, but following this rule adoption in April, it became effective in June, a group of environmental groups had a lawsuit ready to go, and when the EPC adopted it that afternoon, they held a press conference, and they are challenging, not so much challenging the rule, they oppose the fact that the karst separation distances for structures were not changed, and they filed, well, we'll talk more about it, but it's under the Safe Drinking Water Act, filed with EPA, and we'll talk, I have that on another slide, but that was in direct response to this karst rule not changing. All right, Ben, we get to the phosphorus index and sheet and rill erosion. This is one where I think mainly consultants deal with this who use the P-index, but you producers who use consultants and anyone else that works with this, this came out of a 2023 court ruling that said DNR wasn't following the law in reviewing the P-index, and one of the factors in the Russell 2 is sheet and rill erosion, ephemeral gullies, all right? And the court said, hey, DNR rules did not allow photos instead of the NRCS technical guide, and they did not allow not calculating, anyway, gully erosion because it wasn't visible at the time. Court said you can't do that. The rules require you to do it. So, as part of these rules, in this, I'm not going to go through all this. I'm on slide 7 and 8. And if anybody, I'm sure I've talked to a lot of you consultants, and it's kind of a mess out there right now. Those are my words, not theirs, in case DNR's listening. But DNR has told me that this didn't get written right when it got adopted in the final rule. I've got a paragraph A, see that on slide 7, what has to be done for sheet and rill erosion in the P-index. And then there's a subparagraph B. What should have happened was they one or the other should have ended up in the final rule, not both, because they don't work together. They kind of contradict each other. I have been told that DNR is working on a technical rule. Be careful when somebody says something's technical only, okay? But they're coming with another rule to fix this inconsistency in the sheet and rill erosion rule, and probably you're going to see that later in this year. And right now, and you consultants can tell me differently, and I talked to quite a few of you before this talk, but right now, the way it's supposed to be working out there is you get to pick A or B, which one you want to use, because again, they don't work well together. Let's see, what do I have after that? Nope, that's the last one on sheet and rill erosion. Again, it's, I'm going to get myself in trouble if I go too far here probably, but I've been told that some from NRCS, where this originates in the P-index, are saying that this isn't the way it was intended to be used. You shouldn't have to use it in a rule like this. I think we have some more work to do here, but in fairness to DNR, this was driven by a court decision, okay? And I hope we can get it fixed. So, and we need all your input when this technical rule comes out. We'll try and, rule change, try and get it out to you, but really focus on what we can do to make this workable, okay? All right. Next, DNR construction permits, non-construction change. I'm on slide 9, okay, and I've got the rule on the next slide. Sometimes I think, I get fixated on an issue, and this has been one of my pets, okay? This rule we worked hard on, I forget what year we first put it into place, but the whole point was if you're making a change in your site, but you're not pouring any new concrete, not doing any quote-unquote physical construction, you're just making a change. And if that change doesn't result in more manure, okay, you shouldn't have to get a permit. And we worked hard to get that language in there, and quite honestly, we've had a battle over the years. Okay, well, what's a change that you can make that you still should have to get a permit? And we were running into DNR interpretations that if you were switching to wean to finish and putting in gas lines, whoop, that's a change, you need a permit. Now hold it, that has nothing to do. We're not increasing the manure output. It's not a manure storage issue. So this rule now clarifies, and you can see there on slide 9, that if you're making that physical construction or alteration that would require a permit has to be to the manure storage structure, and that to other parts of the building do not qualify to require a permit. In other words, if you aren't increasing the volume of manure and no modification in the way it's stored, and the animal capacity can be increased. You can actually increase animal capacity as long as you're not increasing more manure and no physical construction, okay? Now, is it that big a deal? Just when I think, well, maybe I'm paying too much attention to this, but and here, here's the actual rule on slide 10. Just last night, producer pulled me aside and said, hey, we're taking our sow unit and we're converting to wean to finish. That's exactly what we're seeing some of, and I'm not trying to get rid of sow units out there, but we're just seeing a conversion and I said, you gonna be pouring any new concrete there? Nope, just changing gates, etc. And you're gonna be producing more manure? Well, it's gonna be close. But I said, well, take a look at it, because just what I said, if you have a permit now, or even if you don't have a permit, and even if you're going to be over 1,000 animal units, which is the trigger for a construction permit, if you're not increasing the volume of manure, and if you're not doing any physical construction, look at that rule, you shouldn't have to get a permit, okay? So take a look at this if you have customers or clients doing this. Why do we try and avoid having to get a construction permit? Well, in some counties it requires a matrix. Got to go through that again. Okay, maybe that's no big deal. But just take a look at it to make sure you don't have to do something that the rules don't require. And again, it makes me feel better if you at least challenge it, because anyway, just kidding. Okay, all right. Construction approval letter. This change clarifies that before the letter is issued, that after you submit the construction design statement, MMP, and the other information, and before the letter is issued, if you have some revisions to it, you may make those revisions without having to start over, okay? We've had cases where people say, well, I just made a change. Then they said I have to start the 30-day clock over again, and at certain times of the year, when you're trying to get construction going, that can be very important. The county right to appeal a construction permit. Some counties were doing this anyway. I'm on slide 11. But if you've received your, what counties and many of you call the draft permit, which has a 14-day waiting period if the county may appeal, you can now, it's clear in the rule, you can go to your county, and I know 14 days doesn't sound like much, but again, certain times a year, I've had producers say that's a killer. I've got construction lined up, I've got pigs coming. You can request that the county, if the county says we're not going to appeal, if they can give that waiver to DNR right away, you don't have to wait the 14 days, okay? So that's in the rule and now clearly allowed. Some counties, and DNR was allowing that anyway, some weren't. Okay, what do I have here on this slide 12? And looking at the clock, making sure we're moving along here, Ben. Definitions. They're the bullet point in the middle of the page on slide 12. Complete application. This is one thing we kind of push for, I'll say. It now says substantially complete. What we're trying to avoid here is, a rather, I shouldn't use the word minuscule, a rather minor item that needs to be changed and starting the clock over on you on whatever waiting period we're talking about. It has to be substantially complete to be Okay, here's one, I said slide,
Should be on 13.
yeah, I might have, slide 15 is where we have the chart nobody can read. Okay, slide 13, groundwater lowering tile. This is one of those confinement buildings, if they're built partially or completely below the soil surface, you need a perimeter tile. We all know that. But it's went through variations through the years did you have to have a shutoff? Do you have to have a monitoring port, etc.? And this is the current rule, okay? And here's a slide 14, that tells you the various years where things have changed. And I've used that slide in past presentations. Well, in working with consultants, it's hard to keep track of this. As I talked about in the beginning of the talk, if you go out and look at a site and it doesn't have a shutoff, okay, but when did that go into effect? Well, here's what I came up with, and I hope that you can see it better up there than you can see in your handout. But what I'm looking at trying to do to put in the environmental handbook is a chart like this on various issues where the rule has changed. And I am interested in your thoughts. I know you're just getting it flashed in front of you now. But if we look at this, and on the left-hand column is the date of construction of the manure storage. And then at the top, we have, is it unformed manure storage? Is it formed with a permit required? Is it formed with no permit? Or is it a SAFO, small animal feeding operation? And then we have the requirements in the next row, tile or shutoff and monitoring port required if no surface outlet on the property. And what I've tried to do on March 20, 1996, the first rule was adopted, and it applied to unformed manure storage and formed manure storage with a permit. But it did not, since we don't have X's in those next two columns, didn't apply to SAFOs and didn't apply to formed storage without a permit. So then we go down to March 26, 2004, and it was then the rule changed to require the formed manure storage with no permit to have a tile, but just in kind of a quirk, I think, it did not require, for them anyway, a shutoff or a monitoring port. That rule didn't go into effect until 6 years later. And then it also went into effect at that time for the SAFOs. I'm just looking at a way, if that helps you or producers look at that and say, okay, at the time I built in 2006, I just picked a date there, go across, and if I was a SAFO, I didn't have to do it. If DNR comes out there now and looks at it and says, where's your perimeter tile? Where's your monitoring port? Hey folks, when I built it, I didn't have to do that. Is this sort of thing helpful? And okay, I see some nodding yes. I suppose those of you who don't think it is aren't going to throw anything. Yeah, maybe. Pardon me. I'm looking at trying to do that in other areas where we have the rules that have changed over the years. I guess this kind of chart I thought was helpful, and I've talked to several of you who thought it was, where you can just look at a date and see where you fit in that. Okay? Yes, sir.
So when you reference the date, is that the date that paperwork is submitted to DNR or the date that the manure storage structure is constructed?
There's always somebody picking right down to the gnat's rear end, isn't there? But good question. I have in the column there, date of construction of manure storage. Let's put it this way. If a permit is required, we're probably looking at the date you submitted it to DNR. When you get that close, give me a call. and I joke about it, but you know, we're always going to have those dates where, yeah, a day here or two could depend on whether DNR thinks you're in violation or not. And I'm serious when I say, give me a call. And Ben, if you want to talk briefly, this is not something we talked about ahead of time, but what we do for producers.
Yeah. So the Iowa pork producers, if you're a member of the Strategic Investment Program, and you have a question or a specific question about DNR rules and regulations that you may or may not be sure about, we can refer you to Eldon McAfee if you give us a call, and he can help you out depending on what your specific need is. And so, again, we just want to make sure producers are in compliant when they're building barns and things like that, and so we want to be helpful in those ways.
Okay. Did I sufficiently dance around? But your point is, yeah, there's a specific date when you submit that permit. That's when you're looking at, that's your mark in time. If you don't need a permit, then it's when you construct it. Okay? And I'll we'll see how soon I get it done. But I'd like to do this kind of chart on other areas where the DNR rules have changed. Okay? All right. For example, water source separation distances have changed over the years, and we have had a situation where a producer got a letter from DNR that they were not in compliance with this. I forget what the distance was, and that producer and their consultant got a hold of me, and we looked at the law and said, well, wait a minute. When that was built, this was the distance, not the distance that's there now. So that might be the next one I work on a chart just like that, okay? Kind of switching gears a little bit here, separation distance waivers. We've had the provision in the law since 1995 that if there's a separation distance required, like from your building to the neighbor's house, that's primarily what we run into, that if you can't meet that separation distance and the neighbor says, hey, I'm fine with it, they can sign a waiver, okay? And that waiver has to be recorded with the county recorder for several reasons, but one, DNR requires it. And what do I have here on the slide? The title holder, often it's, forget about what DNR requires, the lender often looks at that and says, we need a waiver there to make sure that nobody can claim that building was built and not in compliance with the law. And I think quite a few of you have, when we first worked on this in 95, and I say we, representing Iowa Pork Producers Association in the legislature working on this law, I thought, waivers, and things were rather contentious then, and they sometimes are now too, and I thought, who's going to sign, that neighbor going to sign a waiver? And but we use them, and you do, quite a bit, and it allows you to build, etc. We have some of the details there, title holders, and one thing I tell producers, and this is not a talk to convince you to get an attorney, but in doing these waivers, and many consultants do them, I'm fine, but make sure you get the right property owners in that waiver. Now you say, come on, McAfee, everybody knows how they own their property. No, they don't. Some have formed a revocable trust. You'd be surprised how many times when we really look into it and do a quote-unquote title search that the actual title holder is not what the people thought. Secondly, legal descriptions. Have to make sure those legal descriptions are absolutely correct. Many of you use Beacon or some other, and it's a great resource on those on the websites, but right on Beacon, doesn't it say these descriptions are not to be used in legal documents? And there's a reason why they say that. They're usually shorter. You need to get the exact legal description, and that's available on Iowa land title records, etc. If you can do these yourself, fine, but you just got to make sure these things are correct. An example I can give you, I had a case a few years ago, neighbor signed the waiver, and then decided later, not sure, I shouldn't have signed that. I don't like that building there. And it turned out to be an issue with notarizing. The producer had the neighbor sign the waiver, and then they took it into the bank where the notary was, and the bank knew the person who signed it but didn't see them sign it and notarized it. That's a big problem because then the neighbor challenged that waiver saying, well, it wasn't properly notarized, and let's just say all's well that ends well, but it was a real battle in a nuisance case for a while over whether that waiver was valid because it had they hadn't had it properly notarized, and that notary lost their notary license for, I forget what it was, 6 months or something. When it says on that notary requirement, when it says subscribed and sworn to before me, that notary needs to see them sign it, okay? And waivers are another example of that, okay? I guess I do have properly notarized there. All right, why do I have it up here? Because in 2016, the DNR rules changed about future expansion. And in 2016, the DNR rule said waivers must be specific to the construction or expansion for which the application is submitted. We have some waivers out there that were signed by people that pretty much just says, I waive it, the separation distance. And it may even say for all future expansions, et cetera, but just pretty much wide open. DNR, at least I've been told, will not accept those anymore. And I was recently told in getting ready for this talk by a consultant that they had a customer who had actually signed a waiver, and the customer had the neighbor sign the waiver, and the neighbor, he actually had to pay for the waiver. Paid the neighbor to sign this waiver so they could build their operation, and it was done before this rule had changed. And it was pretty wide open, and now they want to expand, and DNR is saying, yeah, it doesn't meet our requirements for any future construction or expansion may only be included if the waiver includes specific language describing the future construction or expansion. So this waiver doesn't meet the rule, DNR wouldn't accept it, and the neighbor is evidently saying, I'm not going to sign another one no matter what. And so that producer is having trouble with their expansion. Just wanted to point that out. Any question on waivers or separation distances? Okay? All right, composting. You know, in getting ready for this talk, I always think I'm going to run out of time. I guess I talk too much.
As I've known, you're not going to run out of time. No, but and you talk about distances.
No, I'm sorry. I should have said I always think I'm going to run out of material and be sitting up here with time left, and I don't think that's ever happened.
Yeah, and so getting to our next topic, composting mortalities, obviously looking at different separations depending on where you're at. Can you talk more about what we're looking at here?
Sure. Composting obviously used by a lot of pork producers and other livestock producers. Here on this slide, slide 19, and on the next couple slides, I have the current DNR rule. And the one thing that I have gotten questions on as I went back and looked at my notes over the last year or so, one is, fourth bullet point down, 50 feet from property lines. And I think, composting mortalities, that DNR rule is under the solid waste rules, not in Chapter 65. So it was written at different times under, it's just not, because composting applies to just more than livestock operations. And I think what catches people off guard is we don't have many separation distance requirements in Chapter 65 that apply to livestock that measure from the property line. The only one is the road setback distance and then an irrigation requirement. But generally, if it's to a residence, it's to where the residence is. That doesn't matter where the property line is. But this one is specific. Your composting has to be at least 50 feet from property lines. Two things here. Number one, we're running into a situation, a consultant informed me of, where for whatever reason the composting sites got built pretty much right up next to the property line. And now on some DNR visits, they're saying, okay, that can't be there. Well, what they have agreed to do, is my understanding, is you can get a waiver from the neighbor. Not in the rules, but hey, if it works, more of a variance, I would say, from the rule. And it's working fine according to the consultant I talked to, because the neighbor is the farmer who sold the land off for the hog building to be built in the first place, and so they're pretty agreeable. If you can't, I don't know if we run into a situation where they won't sign the waiver, we probably got another problem, but I'm sure we'll work through it somehow. Okay, that's one of the situations that has come up. Another one that has come up is, what about if that composter is within 50 feet of the fence at the road right-of-way? And this is one that's a little harder to answer, because this just says property lines. Where's the property line at the road, right? Is it where the fence is, or the road right-of-way, or is it at the middle of the road like in most counties, because that's where your true property line is, but the county gets to use that 33 feet? I don't know how to answer that one. I'm looking at the consultant who asked me that question a year ago. I don't know how DNR has come down on it. I'm a typical lawyer. I'll make the argument either way. Which way do you want me to argue? But if you have any input ahead of time, I would stay 50 feet off of where the fence is. But if you have to deal with it after the fact, hey, I'd give it a shot. Any thoughts on that with anybody who's had to deal with that issue, but a property line issue for composting? I know this is kind of getting into the minutia, but if you have this issue, it becomes a big problem. Now, let's go to the next slide. Third bullet point. One of the critical issues for a lot of our producers is, from a biosecurity standpoint, as well as just operational expense, is to have one composting site for multiple sites, right? Makes sense. Let's haul them from one site and only have to compost on the other site. This is specifically allowed by DNR rules. It's the 33rd bullet point down. Composting, and I tried to quote the rule as close as I could here in this slide, it doesn't require a composting permit unless the operator of the site is neither an owner or operator of any of the sites where the livestock were produced. How's that? Kind of comes in through the back door, but that is saying you can do it and not have to get a composting permit, which you don't have to do for on-farm composting. I think there has been a little bit of confusion about whether you can actually do that, but yes, DNR rules allow you to take that mortality from one site and haul it to another site of yours and compost it, okay? Now, the next part is transportation vehicles must be constructed to prevent release of mortality-contaminated materials, okay? And in transporting, the most direct haul route that avoids biosecurity risk must be used. Okay, here's the example I've given in years past. Don't be throwing that mortality, I'll call it, instead of something other. Don't be throwing that dead pig in the back of the pickup and pulling into the Burger King drive-up to get a hamburger, okay? A little more direct route. How's about that? Yeah, and maybe not have the legs sticking straight up in the air. Maybe I'm not being facetious. Hey, a lot of you know I was a dairy farmer before I became a lawyer 30-some years ago. I've been through all this, folks, and things are a little different than when I quit. But you're allowed to do it. Those are the requirements. Any question on composting? I have, let's see. There's still some requirements here I talk about. I've checked with DNR, and composting was not part of Chapter 65 that went through that rule. Composting, as I said, is solid waste regulated by DNR. It's in a different chapter. They're just going through the same process, and these rules are, there is a draft out that a stakeholder group has been working on, And they're going to change. I've looked at the draft. I didn't get involved in the beginning, but I'm looking at it now. And that rule is scheduled to go for formal rulemaking late 2025, so somewhere around September or so. But we're watching it. I know others are. And it's going to change, but so far it looks like what we're talking about here will still be allowed. But no driving through the Burger King. Okay, anyway. All right. Any questions on one last point there at the bottom? If mortalities are composted in manure, the compost pile must also meet manure storage structure requirements. Okay? Don't know that I run into that obviously too much with swine confinement buildings, but we do, like on poultry sites with cattle, etc. If you're using the dry manure to compost and you throw some mortalities in there, anyway, you got to look at the manure storage requirements. DNR construction permit master matrix change. The only point I want to make here is if you want to change your points on the matrix, and I wish I could, I've tried to look at maybe trying to get this changed, but we haven't been able to do it. It's a change to your permit. So you have to just essentially get a new permit. Maybe not a big deal in some counties, but you want to replace some points, whatever it is. I think we need a provision in the rule to allow you to go through a process that doesn't require getting a new construction permit, but right now that's what I've had to do. If you've been able to work with DNR to do something differently that didn't require a permit, please let me know. Okay? All right, I'm on slide 24, and we're talking about manure release reports, something I hope none of you ever have to do, but we do. It happens. Consultants, manure applicators, etc., have to deal with this. Here's what the law says. What is a release that has to be reported to DNR? I'll give you a little background. It used to be that all of this was under the hazardous conditions release reporting. And it's been quite a few years ago. We got it changed so that manure release reports are pretty much the same requirements, but they are not the same as hazardous conditions release reporting, but it is the same spill hotline you call. But here's what the law says. If it is actual, imminent, or probable that there will be a discharge of manure to surface water, groundwater, drainage tile, and then I go through a whole list of things there, but pretty much that first part covers it, then you are to report it. I'll keep going here and then we'll come back. You need to notify DNR ASAP, but not later than 6 hours after the onset or discovery by calling the DNR spill line. Now, some have been told, and well, I also have to call the local sheriff, okay? Here's what the rule says. If the spill involves a public roadway and public safety could be threatened, then you have to notify the local police or the county sheriff within 6 hours. If it doesn't, if you're out in the middle of the field, that does not apply, okay? Following the verbal report to DNR, DNR may request a written report within 30 days. My point to you on that written report, and DNR usually requests it, pay close attention to what you put in that report. It has to be truthful. But what I see is producers sometimes will say, the amount that it was released. Well, they'll say, gosh, I don't know, the hose broke or whatever, but you have to be truthful. I'll say that again. But this is not a place where you want to just say, oh, had to be, I don't know, a couple of 1,000 gallons. Be as accurate as you can, because that's going to be in the record for a long, long time. And sometimes the press picks up on stuff like this. When DNR asks how much, if you don't know at the time it happens, say you don't know, and then try and do some calculations to come up with a number. But be as accurate as you can on that number, okay? And then you have to submit lab results. Okay. I need to go back. Here's why I have that on the list today. the DNR website, if you go to it, it will pretty much say, if in doubt, report it. Well, what am I talking about here? Let me give you an example. The hose breaks on an umbilical application, and you're right there. You see it, shut it off right away, and it's just a puddle right there. Under Iowa law, that is a violation in that you have failed to totally contain that manure, either to the confinement enclosure, the manure storage, or your application equipment. But that's not the question. The question, whether you call that spill hotline, is it a release? Well, if you're out in the middle of the field and it's a long ways away from any surface water, groundwater, tile intake, etc., is it actual, imminent, or probable that it would get there? And if I'm not telling you to, if you believe so, then yes, call that DNR spill line. The situation is these things get reported, and if you don't believe it's actual, imminent, or probable, you're not required by the law to report it. I'll give you an example. Manure applicator called me this past fall, and I still can't believe the irony here, but DNR was coming down the road. His employees were putting on manure with a drag hose, and the DNR was coming down the road to just check their certification, their license or whatever, and right at that instant, the hose broke, okay? But it was in the field, and they shut it down immediately. The little manure got away, out of the hose, but his employees did everything they should have done, did it right. The DNR, seeing it, being right there, said, well, you just need to go ahead and report it. Was it actual, imminent, or probable it was going to get to a water of the state? No, it wasn't going to get there, but they went ahead and reported it. Well, then that gets reported as a manure release. And he was required to submit a written report of this manure release. Well, then some darn lawyer in Des Moines got involved, and me. And I said, okay, I understand, but we put a footnote in that report that that it did not qualify as a release, but it was being reported to DNR even though we didn't believe it was a release. Just trying to protect that applicator from any I mean, it really didn't need to be reported, but I couldn't say don't report it when DNR was standing there. I'm not telling you again, if in doubt, like DNR says on their website, report it. You make that decision. I'm just telling you what the law is. How's that for an attorney waffling on you sitting up here on, but wanted to make sure you knew. I hope you don't have to deal with it, but there's what the law is. Any questions? Okay. Ben, how are we doing?
We do have under 10 minutes left, so if there's a specific area or
well, let's look at the table.
that you think we have federal EPA air emissions, DNR enforcement actions, ag nuisance and trespass laws. And so if there's any specific areas you folks think we can address in the last 10 minutes, happy to do so, as well as Eldon, if there's anything you think they should know. He will be around here through the rest of the day, so if you have any other questions about specific issues you have, happy to address those as well.
I'm not done talking unless you have
We'll keep going.
You get 60 minutes out of me, okay? All right. Here's what I talked about on slide 25 with, I call this DNR rule enforcement. These are environmental groups that DNR does, that they think DNR is not doing their job. So we have the Food and Water Watch research memo that came out in early December that they don't believe DNR's penalties are high enough. They allege that they haven't been sufficient. I'm being kind there. Arising out of that, some of you may have seen, there's a newspaper article that has been going around in some counties where the headline is, and I can't remember it, but it ties manure to cancer, okay? And there's quite a stretch there, folks. If you see that article, please let Iowa Pork know, because we have worked with some on responding to that article about manure and cancer. Can I leave it at that for now? Let's just say no. Okay, that is stretching this study beyond what this study did, okay? The Sierra Club petition, this is the one that, let's see, I'm on the second bullet point there, that they are asking the DNR to take away, or the EPA to take away DNR's authority on NPDES permits. Folks, we've been there. As this points out, I think this is similar to a petition that was filed in 2007. Remember the DNR EPA work plan we went through for years, and DNR looked at all the sites. We've been there, we've done that. EPA said we were fine. I hope EPA does that as well on this one. And then the environment, this is a Safe Drinking Water Act petition on the karst areas, and they're alleging, this is the one that was filed the afternoon after the EPC adopted the rule that didn't strengthen the karst restrictions. And that's still, EPA's taken a look at it, and they haven't taken any action on that petition. Environmental Council is asking EPA to require a lot of the things that are listed on this slide, but just stay tuned, and no action's been taken yet. Apologize for my cold here. Okay. Environmental self-audits. If anything I've said today, or you realize that either you or your clients, customers are saying, hey, wait a minute, I'm not sure about where that composter is located, or I'm not sure, you can always use what's called an environmental self-audit, where you file the right pieces of paper with DNR that say, I've done an audit of my operation, I've determined I have an issue I'm not in compliance with, and I submit the notice of audit, and I submit a notice of voluntary disclosure of violation, and here's how I'm going to fix it. Done correctly, and well, I know a lot of people use them, and done correctly, there will be no penalty, but you do have to correct the violation, okay? Federal EPA Clean Air Act compliance, best I can say here is read this in the 5 minutes we have. This is the part that never goes away. This thing just keeps coming back. The 2005 air consent decrees, remember those things where we had to pay a penalty and file this decree in advance and all that? Well, this study was these methodologies under it's slide 28, the next to last bullet point right at the bottom there. They updated the methodologies, and it was released on November 14th of 2024. I haven't even got through all of those things yet. I don't know if Ben and I have talked a little bit about this. Public comment was to be due by February 17th, but just this last week, it's been extended to May 19th. Just hold tight. Unless you really want to read this stuff, you can Google it and you'll find it, or let us know. But NPPC is working on this. We'll be working with them, and experts are looking at those methodologies. And somebody asked me before I started here today, was I going to talk about the change in administrations? And my answer is no. How's that? Enough said. All right, air emissions reporting on EPCRA, same thing there. And, whoops, now what did I do? Then here's the good news. Ag nuisance cases, here's a list. You've seen this before. And since 2019, and knock on wood, I don't know, those were the last cases that went to trial. I'm not aware of an ag nuisance case on file right now in the state of Iowa. An ag nuisance case. There was one last year on a dairy with stray voltage, a little different, but it was still a nuisance case. But as far as neighbors claiming an odor, flies, etc., nuisance case against a livestock operation, I know none have went to trial since 2019, and those in 2019 did come out in favor of the producer. Since then, in 2022, we had the favorable Iowa Supreme Court decision. So we have, two things helping us there. One, the juries that have heard all the evidence, and here's where I get on my soapbox, people. People can complain all they want, but when the evidence was presented to the juries, the last time that happened in Iowa in 2019, 2 cases and one the year before, the juries came back, no nuisance, okay? don't let our guard down. Keep doing the good things we're doing, and I hope next year, I plan on being back next year and maybe a few years after that, I hope I can keep saying no nuisance cases on file right now in the state of Iowa. Keep doing that. I can't emphasize that enough. Steps to help avoid, we've looked at those before, and that's to help you qualify for the nuisance defense. I still have 2 minutes, Ben. The ag fraud laws, how about, and I've got quite a few slides here, but let's go to the summary slide.
44?
Slide 44. We're in good shape in the state of Iowa, but that doesn't mean you should let your guard down on being diligent in your biosecurity restriction of who's on your site, your hiring of employees. You just gotta, there are people out there that don't like what we're doing in how we raise livestock. We all know that. But we do have good laws in the state of Iowa. I summarize them here, where it is a crime if they take the bottom one, the electronic surveillance and trespass law. That's been found to be constitutional by the 8th Circuit. The food operation trespass law was found constitutional by a district court. The 2019 ag trespass law was found by the 8th Circuit to be constitutional and not a violation of free speech. We have good laws in place that should be a deterrent, but don't let our guard down. Just a quick note there, Ben and I were contacted by another state here just a few days ago looking at Iowa's laws to enact in their state because ours have been upheld by the 8th Circuit. Okay, and the time deadline for asking the U.S. Supreme Court to look at these laws has passed. These are solid. Again, we have protection. You keep doing the good things you're doing about how we treat animals, how we maintain our security, and we'll be in good shape. California Proposition 12 and Massachusetts Question 3. Supreme Court has ruled. I know some of you are following, are complying with the law and doing well at it. I know others are still, we all hoping that something can be done. There are, my last slide there, litigation on slide 50 talks about a pending case in California that is now being, the U.S. Supreme Court is being asked to take that case. We'll see what happens there. Massachusetts Question 3, there are a couple of cases there for you to look at. 10:30.
I want to say thanks, Eldon. Really appreciate everybody joining us today. Like he said, we didn't get a chance to talk much about the policy aspects of the new administration, but we will have a seminar at 12:45 with a former USDA official and former White House staff talking about some of those policy issues you guys might be concerned about if you are. That's taking place at about 12:45.